Hello, everyone. Thank you for joining me today for our webinar, which is how to secure your future with the right estate plan. My name is Lynn St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning, where we serve clients in Spokane, Tri-Cities, and in the Seattle area from our office at the Northgate Executive Center. So thank you for joining me. We're going to be talking about Washington's laws for estate planning. Now, securing your future with the right estate plan all depends on where you are in your life's journey. We'll be talking about different estate plans for different times in people's lives. Our goal of Elder Law Group, ELG Estate Planning, with providing this information on the live webinar and then on Facebook and on YouTube, is to provide information that is easily understandable, it is accurate, and it is appropriate so that you will not feel overwhelmed by all the information that might be coming to you. We want to demystify estate planning, bring down those barriers so that you feel comfortable in taking the next step, the next action to secure your future through the right estate plan. Now, if you've been holding off on doing your estate plan, you are in very good company. I wanted to share with you that I was recently at a meeting of very successful business people. I was speaking with a gentleman who said he has no estate plan, and I was kind of flabbergasted. I thought that somebody who is a successful business person, of course, they understand the importance of an estate plan, having it in place, yet he didn't. And part of our discussion was because there's no urgency to it. You don't need an estate plan until you do. You don't need an estate plan until you pass or until you no longer can make an estate plan. It is too late. So I want to talk with you a little bit about what does that mean to be too late. Obviously, we all understand what it means, that if you passed and you don't have an estate plan, there can be a lot of problems that you leave for your loved ones. But what this gentleman didn't think about, and he had a very simple situation. He was single, he had one daughter. It would be really easy to put an estate plan in place for him to make things quite easy for her when he has passed. So we talked about that. And I said, but what happens if you should become incapacitated? I mean, nobody wants to think about losing the ability to make their own decisions, but we know what happens. So what he didn't realize, and one of the things I want to make sure that I share with you so that you do realize, is that if you lose the ability to make your own decisions while you are alive and you don't have in place the right estate plan, you will be subject to a court-ordered guardianship or conservatorship. Now, what does that mean? So as I explained it to him, what it means is, and maybe your daughter will be appointed as the court-ordered guardian for you, but all of your affairs, your financial affairs, your personal affairs, everything is laid out in a plan in the courtroom in the county where you reside. So can you just imagine the horror of this? To this gentleman I was speaking with, I do believe I created a little bit of urgency with him. If something were to happen, if he were to have a stroke, if he were to be in a car accident, some other bad thing happened to him, so he can't make his own decisions, then everything in his life is in the courtroom. He's under a court-ordered guardianship or conservatorship. His business, all of his business interests are laid out in a very public record in the court. His personal care plan, what his day-to-day looks like for taking care of him, is all laid out in a very public report that's accessible to anybody because it's under a court-ordered guardianship We now also call it conservatorship here in Washington. All of that can easily be avoided by having a good plan, in particular, a good general durable power of attorney for finances and a durable power of attorney for healthcare. So when it comes to estate planning, this very smart, very successful businessman didn't realize that he was missing a big part of the picture of an estate plan, which is not just what happens when you die, but what happens if during your lifetime you become incapacitated. If you don't have an estate plan yet, you are in really good company, but it's really not that great a company. You want to set yourself up for success, which means having the right estate plan for you or wherever you are at in your life's journey. So you may be older, and that means your estate plan might look different than if you are in midlife, or if you are younger and you have minor children. We'll talk about how those estate plans might differ depending on your circumstances. Also, your circumstances might be that you are in great health, and all your loved ones are too, or your circumstances might be that you are not in good health, or perhaps somebody in your life is on government benefits because they're special needs. Perhaps you're younger, you have minor children, there's a blended family. All of these factors come into play to say, what is the right plan to secure your future? So I mentioned that it's one of my goals to make sure that the information that I provide is easily understandable and digestible. And it made me think to how we are now receiving and getting information. For those of you who are old enough, you'll remember back to when we had 3 TV stations. There was news every night. The news was news and everybody watched it. And if you wanted your channel changed, well, your kids were your remote control. So a lot of you listening might not know what the heck I am talking about, but for those of you that do, what's different nowadays is that information comes to us from so many sources and so quickly. I mean, yeah, sure, there's TV and you can watch it in different ways, and you can get things on your iPad or whatever device you have on your phone. Some people watch the national news. Some people don't. Some people get their news from a comedy or some comics. Some people get it from TikTok or from Facebook, or you name it. Information comes to you from all different places, and it's not necessarily accurate or true or understandable or meant to benefit you. It could be meant to benefit somebody who wants to get a lot of clicks, and it's hard to know what is good information. So just for fun and preparation for talking with you today, we looked up what ChatGPT would say is a good way to approach a webinar on estate planning. So I'm going to share my screen just briefly. And I took a look at this, and it's a webinar title, Mastering Estate Planning, Introduction. We've done that. Goals of the webinar, understanding of estate planning, defining key concepts, estate, probate, trust, wills, common misconceptions. What are the components of it? Steps to create it, special consideration, roles of professionals, common mistakes to avoid, questions and answers, resources, conclusion. Okay, I think that's a pretty good outline, but I can tell you what it is, how even I took a look at it, and I'm an estate planning and elder law attorney for many, many years. I go, there's a lot of words there. Tell me, what's the concept? What's the story behind that? How does it impact depending on what your situation is? And nothing is there. It's just a bunch of words that aren't put together in any context. And so I think that might be one of the real issues with AI, artificial intelligence, chat GPT, or whomever you're talking to, is you need somebody who is actually a person who can counsel and guide you and understand your situation, your goals, where you're at life, so that you can have the plan that makes sense for you, because a plan that makes sense for you is not the plan that makes sense for your kids or for your neighbor or for somebody else you might know, because your situation is unique. It's for you. So, I just caution people when they're looking at, hey, maybe I can do my own estate plan. I'll just pull up a form. Yeah, you can pull up a form and the words make sense, maybe, but the plan doesn't. And it may not be appropriate for you. It likely isn't. How do you know that? In that you have not spoken to somebody about your unique situation. And if you do have a plan, will it work on your death? Maybe, maybe not. I don't know. Will it work if you should become incapacitated? Hard to say. Plans are not challenged until the event occurs. You don't know whether or not you have a good estate plan until probably it is too late. So you need to put a whole lot of confidence either in a form that you find online or in an estate planning and elder law attorney that you are comfortable with, who speaks to you, who cares about your situation and wants to make sure that you're going to be taken care of and you're just not, a form or a document or something along those lines. So that's why I'm really passionate about this. I will just share very briefly in my own life. My parents both required long-term care, and I was the person helping, making sure that that care was delivered appropriately. And this was 14 years of my life, and that's what led me to being an estate planning and elder law attorney, just stepping up to what the needs in my family were. Before that, I was a litigator, one of those courtroom trial people, and I can tell you this is so much more rewarding, helping people proactively plan and get an estate plan that's going to protect them so that they and their family have that peace of mind, so that their assets are protected and they don't need to worry about becoming this public courtroom guardianship person, that really is a really bad result for people that don't have a good estate plan. So we'll talk about all the benefits, a lot of the benefits of having an estate plan and a lot of the downside, because you need to understand both. So let's go ahead and move on and talk about what is a good estate plan for somebody who is an older person. Well, one of the first questions then is, what is your health? Are you going to need long-term care? Most of us think that we'll never need long-term care because most of us think that, we are as young as we used to be when we graduated from high school. I know I'm not alone in that. But the reality is that when people hit a certain age, there is not just a possibility, but a probability that they will need long-term care. And the question is, for how long? Will they need it just for a short time, or will it be many years of long-term care? Typically, the many year situation involves with some cognitive decline, Alzheimer's, for example, possibly a Parkinson's patient with any kind of disease that is debilitating and progressive. That is a reason to plan for needing long-term care, possibly using government benefits to pay for long-term care. And if you are married, making sure that on your death or on their death, if you're the survivor, that assets are protected so that there is a nest egg for the surviving spouse. Now, all of that can be accomplished by having the right estate plan according to what Washington State says needs to be the right estate plan if you want to protect against long-term care costs. So what does that look like? For anyone who is living in Washington, they are married, and they want to make sure that their spouse won't be left impoverished against long-term care costs, that requires a will. And you're probably going to say, yeah, when I know that, people need a will. Well, there are more foundational documents than just a will. I'm sure you've heard of a revocable living trust. A revocable living trust is a way to set up your estate plan such that upon your death, your assets go under the terms of the trust to whomever you said. Maybe it's your spouse. Whereas a will is something that takes effect only upon your death. It has no effect until you die. And that type of estate plan requires probate. And a lot of people have heard that probate is a terrible thing to be avoided. You may know that in the law, when you ask a lawyer, is this good or is it bad? The answer might be, it depends. It depends. What is your situation? Your situation may be such that having a will that goes through probate is absolutely the best thing for you and for your surviving spouse. Or your situation may be a revocable living trust is better. It's better to avoid a probate. Which situation is right for you? Let me give you some examples. With a revocable living trust, that is a document you create while you're alive, and you must put your assets into it. Your home has to be retitled into that trust. And by the way, Washington, our recording fees for filing documents are the highest in the nation. But that doesn't mean you won't want to put your house into your revocable living trust, because for your revocable living trust to act appropriately as it's supposed to, so that it can be implemented, your house needs to be in that trust, as does your bank account and your investment accounts and anything else that you can put into the trust that should be in the trust. What can't be in your trust? Your IRA, your 401k, obviously your pension, because that's an income stream, not an asset that you can, not like an IRA. But so you have to understand your trust well enough so that you fund it. And then throughout your lifetime, you must manage it. You have a new account, title it in the trust. If you become incapacitated, there's a successor trustee. They manage everything. So a trust can be a revocable living trust can be a really good planning tool. It depends on your situation. In Washington, we don't often recommend it, unlike other states like California. The recommendation definitely is a revocable living trust. And I may be dating myself, but Susie Orman, who's a financial planner, you can buy her documents online. She's not a lawyer, but she sells documents. She'll say everybody needs a revocable living trust. And some financial planners will too, because they don't understand why you might not want a revocable living trust. So why do people like them? Because they avoid probate if they are set up correctly, which frankly, oftentimes they're not. They're not managed correctly. And if you have a revocable living trust, you know that you also have a will that's termed, it's called a pour over will. Why is it called a pour over will? It's because for those assets that aren't in the trust, they have to go through probate through this will that puts them in the trust where they should have been in the first place. So on death, not only is there a trust administration, which by the way, must be done correctly, but there's also a probate because a trust wasn't managed correctly. Often, very often, we see that with revocable living trusts because people don't understand what they're supposed to do and they're hesitant to go back to their lawyer. Their lawyer didn't explain it correctly. The lawyer, if they contacted the lawyer, they're fearful that they're going to have to pay more fees and they don't want to pay more fees. They think of a revocable living trust as one and done. It is not. It is for the rest of your life, you must manage. So keep that in mind. If you think that a revocable living trust is great, you don't need to do anything, and on death, it'll do it all itself. No, people need to be involved and do their jobs correctly, which they often won't do because they won't involve the lawyer, because they don't want to pay the lawyer, and so it doesn't end up as intended. So a revocable living trust is supposed to avoid probate. Sometimes it does, sometimes it doesn't. Why is it a good planning tool if it's done correctly? Let's say you have property in Arizona, for example, or California, but you're a resident of Washington. You don't want to do probate in every place where you own real estate. A revocable living trust might be a good idea. Now, is it a good idea to have a revocable living trust if you don't own property in multiple states just to avoid probate? Maybe, maybe not. What's your situation? Well, you might be saying, Lynn, I have been told probate is horrible. If you've been told that, you've been told that either by the news or some outlet or by somebody who is selling revocable living trusts. We've heard, I'm sure we've all heard something called trust mills. I mean, it's really not the legal planning that is the standard. It's just sign a revocable living trust, you're done. They might be saying probate's horrible, but in Washington state, what I will tell you is probate is not horrible if it's a good estate plan. Our rules are clear. There is no court intervention, meaning if the estate qualifies, which will be the case if it is a estate that has more assets than debts, and then the court won't be involved. The court will simply sign an order that says the executor, the personal representative, is appointed. They go do their job, hopefully with the help of an attorney who makes sure they do it correctly. Creditors are notified, assets are gathered, the estate, if there's any taxes owed, they're paid, and then the assets are distributed without the court being involved in the process. So in Washington state, probates are not to be feared just because it is a probate. They would be something to be avoided if there's no benefit, or if, well, typically probates, they'll often happen because somebody had no estate plan. So it's going under the laws of intestacy, meaning that there was just no plan in place. And as a result of that, yes, there's often problems. But with a good estate plan, probate can be a really smart thing to do. Let me give you an example. So if you're an older couple and you're concerned about long-term care costs, for example, maybe your spouse does have a condition which will require long-term care, and it's going to be expensive. I think one of the biggest fears that older folks have is that they're going to run out of money. And if they face long-term care costs of $10,000 a month, $15,000 a month, it's not going to take long for them to run out of money. So this is a real genuine concern that people have. Here's what an appropriate estate plan to secure your future might be if you are in that situation of being older and concerned about long-term care costs. I'm going to take a really simple example. Let's take Betty and Fred. Say they're in their 80s. Let's say that they have $1 million estate. What that means is we're not concerned about estate taxes. Just have $1 million estate. Okay. The house is worth 500, their investments are worth 500. In that kind of situation, we likely would recommend to this couple that they have a will, which includes a mandatory asset protection supplemental needs trust. You know, that was a lot of words. What is that? In their wills, each of them will have within it a trust to benefit the surviving spouse. So the trust doesn't take effect until the will takes effect. The will takes effect when somebody dies. When they die, there is a probate. The will must be probated. Through that probate, this new trust that was within the will is created. That trust will hold the assets of the deceased person. So Fred and Betty, let's say Fred was frail, he died first. On his death, Washington is a community property state, so I'm going to use an example of 1/2. Let's say we put $500,000 in the liquid assets, not the house, into this trust for Betty's benefit. Why would we do that? The reason we would do that is Betty is going to need long-term care, or she's concerned she will. If she's got Alzheimer's, we know likely she will need long-term care. Even if she doesn't, she knows that she sees it in her friends around her and other people that she might be needing long-term care. By putting the first spouse to die, Fred's half of the estate, the $500,000 into this trust when he dies, that will be Betty's nest egg. It is for her benefit, only for her benefit during her lifetime. It is for her. Most couples want to provide for each other. But let's say Betty needs long-term care. Let's say that when Fred died, he'd been caring for Betty at home. She has Alzheimer's, for example. She's going to need to move to a memory care facility because there's no way she can live independently in this house. She needs care. So, depending on where Betty lives, what is the facility going to look like? It's a memory care facility. From Medicaid's point of view, Medicaid will say, Betty, you are immediately eligible for Medicaid. And you might be going, what? How is that possible? I had heard that Medicaid is an impoverishment program for single people, and being a widow, she's a single person. That's true. But what I want you to understand is because this couple had the right estate plan, when Fred died, he was able to protect his share of the estate, $500,000 for Betty. That $500,000 that is in this trust, Medicaid ignores. Medicaid doesn't count it as belonging to Betty because the will had a trust with this supplemental needs trust language in it, such that the state of Washington looks at it and say, that's not Betty's money. So what does Betty own other than she doesn't own the trustee is actually the legal owner of this trust. The trustee could be the kid's adult son, adult daughter, some family member that's reliable. So what else does Betty have? She has a house. It's worth $500,000. A house is a non-countable asset for Medicaid if it's below a certain level of equity, which is above $1 million for a single person. So Betty is immediately eligible for Medicaid without any required spend down. Will she go immediately into a Medicaid paid facility? Maybe, maybe not. Depends on where she lives. If she lives in Kennewick and Tri-Cities, the answer is probably she can. If she lives in the Puget Sound area, it's probably no. She's going to have to privately pay at a facility until their private pay requirement, which could be 3 years, could be less, could be more, is met. But regardless, what's going to happen is that $500,000 that's there, even if that was the only asset, it can pay for her private pay, but nothing in that trust will ever interfere with her eligibility. When it comes to providing long-term care, we are very much advocates that you work with an aging care manager to make sure that it's proper placement. The placement is the most important thing. Then the asset preservation Medicaid plan comes next. But what we can accomplish with having the right estate plan for this older couple concerned about long-term care is we can protect half the assets with certainty. Can we protect 100% of the assets? Possibly we can. If we knew that Fred was going to pass away, we can take and put all the assets into his name via a separate property agreement. Everything is his on his death. Everything, the $1 million funds that trust for Betty and for her future. That's how you can secure your future for you and your spouse with the right kind of will, if that is your situation. Now, probate, probate is going to be required. Let's say that probate costs $10,000. That's possible. It can be less, it could be more. I'm just letting you know that probate will cost money if an attorney does it. We've protected $500,000 to $1 million. Whereas if you avoided probate because you had a revocable living trust, you can't protect any of that money. Medicaid will count it all. You cannot use a revocable living trust in the state of Washington to create that nest egg for your spouse against Medicaid spend down. So very big differences between a revocable living trust and a will in Washington. So in this situation, you can see how a will with this trust in it and a probate makes a lot of sense. I've been talking about what happens when somebody dies. Please keep in mind, and I alluded to earlier, sometimes the biggest risk to somebody's future is not that they died, but they had a stroke, or they lost capacity because of dementia, or some accident caused them to have some kind of brain injury. These things unfortunately happen. A good estate plan will always prepare for that by having what I call living documents. I call them living documents because these are the documents that are essential to have in place while you are alive. Those are your durable power of attorney for finances, your durable power of attorney for healthcare, and your healthcare directive. It's also called an advance directive. It's also called a living will. It's not a will, but it's called that. That's where you put in your wishes if you are at end of life and the doctors say, you know, with all reasonable medical probability, this person, no matter what treatment we give them, it will be futile because they are terminal or in a permanent vegetative condition. That's where you make sure your voice is heard. Do you want that or do you not? Do you want to be allowed to die without heroic measures, or do you want heroic measures? You know, it is your choice. Make sure your wishes are in writing and known. That's your advance directive. Who will speak your voice? That is your healthcare agent under your healthcare power of attorney. That person should know you, should know your wishes. And you know what? I do want to say, often it's not that uncommon that people don't have a family member. You might be single and there's nobody that you would want to be your healthcare agent. There are professionals who know what they're doing, who have a fiduciary responsibility to be your advocate, your agent, and they will speak for you. So keep in mind that if you're kind of, I don't know who to appoint, your attorney, their job is to sit with you, talk with you what options are, and bring you to a place where you're comfortable with the resolution of who you have chosen. In any kind of power of attorney, don't just name one person, name an alternate. And if you can, name another alternate. So there's, for example, 3 people, my husband, my daughter, my son. Don't make them joint. Have them have independent successor first, then second, and third. We see a lot of problems when people have a joint type of decision making. This isn't supposed to be a committee. This is one person that you designate in the first position because they know you, you trust them, they will do right by you, they will be your voice, and that's who you appoint. You'll also want a durable power of attorney for finances. I already mentioned earlier about what happens if you don't. You will be a court award of the state in a court-ordered guardianship, conservatorship, with everything being public. Avoid that. Have a good durable power of attorney. When it comes to what do I mean by a good durable power of attorney, we come from an elder law perspective where we know Medicaid strategies. We know how to protect assets in case of long-term care costs. So in ELG's estate planning documents, we will discuss with you having authority to revoke a community property agreement, enter into a separate property agreement if you're married. Remember what we talked about with Fred and Betty? If we knew he was going to die, we'd want Betty to give all the assets to him. Well, if Betty has dementia, she can't sign any documents, but fortunately for them, they did an estate plan before she lost her legal capacity. So her agent, her durable power of attorney, can sign a document that's a separate property agreement that says everything now is going to go to the spouse who's dying so that everything can come back into the trust for the surviving spouse. So that's the type of authority that an elder law attorney might include. Then an estate planning attorney would go, why would you want to do that? The reason they say that is they don't understand how we do Medicaid strategies and how we can protect more assets. We understand how to do that because we file Medicaid applications, we do Medicaid asset preservation strategies. Knowing what Medicaid's rules are, we're going to make sure that our clients have robust, durable powers of attorney to protect them in all ways that are possible. So that's just one example of what would be included in a good durable power of attorney. So we've been talking about an older couple. I will say that everyone needs an estate plan. Some people seem to need it more. Obviously, as people get older, there's more of a sense of urgency. So they're more likely to meet with an estate planning elder law attorney and get it in place. But anyone who has any level of assets should have an estate plan. And frankly, anybody that has no assets, because an estate plan isn't just a will or a revocable living trust. It's those living documents we just talked about. For those of you who can recall back, I'll mention the Terry Schiavo case. That was a situation, very tragic, where this person lost all of her ability to manage her own affairs. And there was quite a dispute between her husband and her parents, who would be making decisions for her. So this all played out in a very public scene where if there had been for this younger person, durable powers of attorney for finances, for health, and a healthcare directive, we never would be having this discussion. But it does happen. So regardless of a person's age, they need living documents, or certainly they do. So let's move back from, we've been talking about an older couple protecting assets against long-term care costs when one dies. I do want to mention that for an older couple, when we do an estate plan, we're also going to make sure we're thinking about how to protect assets for them if they're both alive and somebody needs long-term care. And there are other times when I've discussed that, so I'm not going to get into the details, but it's really important that people understand that there are ways for people who are both alive, a couple, that they can protect assets and qualify for Medicaid without a required spend down. There's some very good strategies that an elder law attorney with expertise in Medicaid can help you implement so that you don't need to spend all of your money down. All right, other phases in life. Let's go down to people who are don't consider themselves older. They're not retired, but maybe their kids are grown. At this point, their estate plan will probably look a little bit different than somebody who is older. They might have a will that has in it not a mandatory trust, but a contingent trust. What I mean by that is that their will might say, on my death, everything goes to my spouse outright and with no protections. But at ELG Estate Planning, we will include in the will that same kind of trust I was just describing for an older couple, but it will only come into being if, on the death of the first spouse, the surviving spouse needs asset protection. So if they're both healthy and their will says outright on the death of the first, and the first spouse dies and the surviving spouse is healthy, then it could be a very simple administrative process when the first dies, not even requiring a probate. It could be just what we call a lack of probate affidavit. Very, very simple. And then the surviving spouse has all the assets and they can do whatever they want with them. And it's, there's no protections, but the couple didn't want any protections. But let's say that the situation is that this couple I was just talking about, the first one dies because they were both in a car accident. The surviving spouse is not healthy. That person has been rendered incapable of working. They're going to need care, etc. that contingent trust that is in the will now can come into play because the person needs it. This is the decision that's made at the time of death, so that those asset protection provisions, the trust, can be put into place, even though it's a contingent trust. The decision is made by the personal representative at the time of the death of the first spouse, that the surviving spouse needs it. So they can also benefit from asset protection, even though their plan was, hey, it's going to be a simple administration, no probate on the death of the first of us, because we don't think anybody will need asset protection. We'll still build in protection such that if that car accident happens and that surviving spouse needs that trust can come into play and will protect assets. What about if the couple has any age, people have blended families? I really want to make sure that if you have a blended family situation, you talk through what happens if one of you dies. If you leave everything outright to your surviving spouse, let's say you have 2 kids, your spouse has 2 kids, everybody gets along, it's just fine. If you don't put a trust into your will that says, on my death, everything goes to my spouse, but it's in this trust, and when my spouse dies, everything goes to my kids, then what happens if you don't put that in place? So let's say instead of that, you say, on my death, everything goes to my spouse outright. Okay, now what's going to happen to your kids? Well, maybe your spouse remarries. Maybe your spouse loses touch with your kids, contact. Maybe your spouse just does a new will and says everything goes to the spouse's 2 kids. That happens, and I'm guessing you know of situations where it has happened. So if you want to make sure your kids do get something from you, from your estate, when you die, when you're gone, a trust in a will is the best way to accomplish that, if you want to also provide for your surviving spouse. So your lawyer will talk with you about how to make sure your kids are not disinherited by you. Okay, let's talk about a younger couple. They might have minor children. They're not thinking about disability or long-term care. Of course not. That's not where they're at in life. They're trying to figure out how to pay for daycare and how to save for education and the things that are really important to a younger couple. In your will, you will want to have a trust for your children. What if both you and your spouse die at the same time? You'll want your kids to be provided for in a trust with a trustee. But more importantly, perhaps than that, is that you need to name a guardian who is going to raise your kids. And then if that person can't, who is the next alternate guardian? It's extremely important that you put this in your will, because if something happens to you and the other parent, the court will likely appoint the guardian that you have named, unless there's a good reason not to do so, like they're a felon or something. But you wouldn't appoint such a person. So even younger folks really do need to have an estate plan that includes not just the living documents, but also what happens on your death. I know you're not thinking about dying. This is no surprise, but you are now a parent and your kids are probably your number one concern. And of course, you want to make sure that you've got in place the right plan for their future, even if you're sadly not a part of it. So you're going to want to name those guardians. So what is the right estate plan for you? It depends on where you're at in your life's journey. We haven't talked very much yet about, well, what if you have a special needs child or somebody in your life who maybe are not special needs, but they have lifestyle issues that cause them problems, drug abuse, alcohol abuse, gambling, financial issues, creditor issues. You can make sure that that loved one is provided for. The best way to do that is by having a trust in your will that's an appropriate trust for whatever their situation is. So a lot of what I've talked about is situational. What's the right plan? What's your situation? I can't get that from the ChatGPT outline. And I've been in practice for many, many years, but from being in practice for so many years, you know, we are very familiar with typical life situations and what people need, what will serve them best, depending on what their needs are, their situation, their goals. We haven't talked about folks who have a taxable estate. I do want to mention that in Washington, our taxable level is just over 2 million, 2.193 million per person. And that used to seem like a lot of money. And then house values went up, and lots of people have very expensive houses now, and they don't feel like they have a taxable estate, but you know what? They might. The federal level right now is 13.61 million, so much, much higher, but it's slated to sunset such at the end of 2025. Depending on what happens at our federal government, it may go back to about a 7 million level, or it might be, who knows what's going to happen. That's yet to be determined. People that have taxable estates really need to be talking to an estate planning attorney who can help them with tax planning, because a simple credit shelter bypass trust in the will of somebody, and it doesn't have to be the will, it can be an irrevocable living trust as well, can save literally hundreds of thousands of dollars. And this is a couple situation. So if you have a taxable estate and you've been putting off your estate plan, it might be a good time, you know, to talk to an attorney who can help you with that. So I am going to take a look at our questions and answers to see what I might be able to answer for you. The question is, does a trust need to be established for a specific number of years, say 5 years, before assets can be protected? It's a really good question. So the answer is, it depends on the situation. So let's say this trust is a trust that is created by a will. So we're not worried about a specific number of years. The trust likely will go on for the lifetime of the surviving spouse. If it's a descendants trust, it could go on for their lifetime for various reasons. A grandkids trust, it might go on until they're 25 or 30. Just depends on your situation. But I think what's behind this question is an understanding that Medicaid has a 5-year look back. So what that means is, if you give your assets away, then you should do so 5 years before you apply for Medicaid. Does that rule impact what I was just talking about with a will and a trust for your spouse? No, there is no look back between spouses. Your will, whether you create something for your spouse or for somebody else, there's no look back. So don't worry about that 5-year term or plan. But if you are working with a Medicaid attorney to do a Medicaid strategy, you might be discussing, well, let's create a trust that is created 5 years before the person needs to apply for Medicaid. And we've done that. For example, perhaps there's a family farm, or perhaps there's a legacy property. They might want to put that asset into, you know, an irrevocable trust, an LLC that goes in an irrevocable trust, or something along those lines. So it's the timing of when you give away these assets to others who are not your spouse that is important for Medicaid eligibility. A really good question. All right, I am not seeing any other questions in the question and answer. So I hope that you found this information useful, and I hope that it gives you a sense of empowerment, that you can take action to get the right estate plan in place. And I very much hope that you don't wait. I know there's so much going on in all of our lives. that just doing one more thing might seem too much. And we all get that. But if you're thinking about an estate plan, then now's the right time to do an estate plan. Do it before you're not able to do it. If you're watching this because you're trying to help your parents get an estate plan, more so the reason to get that estate plan in place. You know, a lot of times people come in and they go, well, I'm helping my parents. Keep in mind that you need an estate plan too. And a lot of people don't realize they need an estate plan. Like that business person, this successful gentleman running this wonderful business wasn't thinking about, you know, it is really important to have an estate plan. So we're ELG Estate Planning, Elder Law Group. We have an office in Kennewick in the Tri-Cities and Spokane. We have a Seattle office at the Northgate Executive Center too. You can reach us at our website, which is elgwa.com. We also have a YouTube channel with a lot of really good information. So check it out. And if you like it, you know, like and subscribe and share this information. My goal is that we make estate planning understandable so that you yourself get the right estate plan. Thanks again. I appreciate your time today. Take care.